Number 118. Counsel, do you want any rebuttal time?
Yes, 2 minutes, Your Honor.
2 minutes. Go ahead.
Good afternoon. Carl Kaplan, the Center for Appellate Litigation for Appellant Mr. Pacquette. Your Honor, I'm going to cut to the chase because we're the last argument. Detective Vanacor's...
Thank you, counsel. Go ahead.
A wise course.
Detective Vanacor's non-noticed show-up identification was not confirmatory because it fell far below the standard that this Court articulated in Boyer.
Does it have to be face-to-face, up front, close? Is that a right-line test?
That is the gold standard, Your Honor. I'm not making a categorical argument that it has to be face-to-face.
This wasn't even close.
But this was not close. I would say it has to be face-to-face or pretty darn
well,
close to face-to-face.
Boyer is narrower than our earlier, like Wharton and that
yes,
kind of
but I think the rationale...
Falls somewhere in between.
Excuse me, Your Honor?
Falls somewhere in between Wharton and Boyer.
This case?
Yes. Or you say no, you say it's outside of them.
This case is, Boyer covers this case. Boyer, the standard in Boyer, I believe, was not a new standard. It's just reaffirmed the standard that because we're talking about an exception to the notice requirement, the exceptions have to be very limited.
Well, counsel, in this case, I'm sorry, you're saying that this was not face-to-face, but maybe the terminology has changed since I sat on the trial court, but Officer Vanacore was acting, Detective Vanacore was acting sort of as the ghost, correct?
He was somewhat of a ghost, yes, Your Honor.
But he was the one who actually called in the description of the seller to the backup team, correct?
Correct, Your Honor.
And so his description was accurate enough for the backup team to apprehend Mr. Pacquette.
Correct, Your Honor.
And he saw Mr. Pacquette running when the backup team arrived on the scene, and he was wearing the same clothing that Detective Vanacore had, and had the same description, 6 foot, 6'2", same weight, all of that, within a very short period of time. So that doesn't sound exactly like Boyer to me.
Well, Boyer was not a buy and bust operation.
Exactly.
But the principle, well, I have lots of things to say in response, Your Honor. First of all, the principle of Boyer applies. I wanted to get that out, which is that the critical factor is the initial viewing. It has to be so clear that the subsequent identification cannot be mistaken. That's the quote from Boyer, cannot be mistaken. Zero chance or risk of mistake due to possible suggestiveness. That's an extremely high standard that is satisfied by a face-to-face encounter. That's the gold standard. Or something factually similar. In Boyer, the officer, it was 40 to 50 feet away. In Newball, it wasn't a ghost officer, but the identifying officer was in a car 50 feet away. Yes, Your Honor?
There's always some risk of mistake. I mean, even if you're face-to-face, it could be, you know, your identical twin, right?
Well, the mistake is not just a mistake, right? It's a mistake.
I'm sorry, Your Honor?
The mistake is of a particular category based on some suggestive, right? Based on suggestion, based on the circumstances.
It cannot be mistaken based on, it cannot be the product of suggestiveness.
Well,
there has to be zero risk of that.
That's my point, counsel. Detective Vanacore saw this man allegedly selling drugs, called him his description. He was there to look and observe at drug dealing, unlike the detective or the police officer in Boyer who had been called on the scene by a civilian. The whole point of this was more like Wharton, where this was a buy-and-bust operation.
Correct, but in Wharton, the critical fact in Wharton was it was a face-to-face encounter. By the purchasing undercover, this Court has never held that there's an exception. The Wharton exception is expanded to a ghost officer who's 40 to 50 feet away across the road. Your Honor, what we're saying, I think, is, and I think this is what my learned friend is saying, it's a question of degree. And I would say the degree has to be extremely high because we're talking about an exception to the notice requirement. Let them give notice or reverse and go back, and then they can do an independent source hearing, and they can make that argument to the independent source hearing.
What about harmless error in this case? I mean, it didn't all depend on Vanacore, right?
No, Your Honor.
The undercover had a face-to-face interaction testified, right? So why isn't it harmless error, even if you're right, even if we accept it, even if we accept your argument?
Thank you, Your Honor.
And he runs, so it appears he's got the consciousness of guilt?
I'm sorry, I can't
And he
hear you.
runs as soon as the police identify themselves?
Yes, but
Constitutes
he ran when the officer was in
buy
plain
money,
clothes.
too. Not to mention that he has the pre-recorded buy money in his pocket.
He has pre-recorded buy money on him, yes, Your
That's
Honor. I
pretty
have a lot of
strong
bullets
evidence, isn't
flying at me right now.
And the diner's given up a lot of singles. That's a little unusual, too.
There are two prongs to the harmless error requirement. The evidence here was not so overwhelming as to negate the error. There were no drugs found on him. If you take away Vanacor's testimony, you have one identification. It's a single identification case. He was the officer who identified him was a 4-month rookie in narcotics. He testified that during the transaction he was staring primarily at the seller's hands, which is understandable. I would do the same thing, but that is a credibility
but he said he looked
deficit.
up, did he not? Did he
Excuse
say,
me, Your Honor?
I looked at the hands, but I look up at his face. Did
He
not
also
say
said
that?
he said, but he focused on his hands. I'm not saying he didn't look at his face, but his focus was on his hands. He testified that he couldn't remember his J.D. name initially. He couldn't remember the color of the hat. So, yes, he had pre-recorded buy money, but my client had an explanation of why he had the pre-recorded buy money. He went to buy food in the diner. I want to focus the Court's attention, if I can, on the second prong, which is that Vanacor's testimony infected the verdict to a considerable degree. Now, we can argue, and I'll take a question, whether it's constitutional error or non-constitutional error under either standard. I think we win. Vanacor was a 10 or 11-year narcotics veteran. He had gravitas. He was an excellent witness. That is why the people put Vanacor on the stand as a repair job, because the first officer, I say, if you read the transcript, was not such a great witness.
Did they announce him during the opening? Did they not
Yes,
refer to him
yes.
during the opening? So before the testimony, they had already
Yes,
made
but
that.
presumably the ADA knew that he was not going to be a great witness, and counsel said when he objected to the non-notice, I'm surprised, I'm shocked, I'm astounded. So I think Vanacor's testimony bolstered the weak testimony of the undercover, the purchasing officer, and infected the verdict. I wanted to say I don't think the record shows, Your Honor, that Vanacor saw the gentleman running, my defendant's running. My understanding of the record was that after the set, the purchasing undercover went that way, and Vanacor, whose primary job was to watch his back, went with him that way, and said he saw as he was walking, he turned around and he saw my guy. But not that he was running. I think he said he saw a police van approaching, and that was it.
I think the record does show that he saw him start to run when the backup team arrived on the set. Mm-hmm. And it is, and I don't think we can forget, counsel, that I know there are quick change artists out there who can change their clothes in a second, but your client had on the same clothes that were in the description.
Correct. But the description, Your Honor, is Vanacor testified during the ad hoc warrant hearing. The male black who was tall wore a light-colored sweatshirt and a dark baseball hat. This is on a summer night near Washington Square Park. That is somewhat generic.
May 17th, not summer up here, I'm telling you. This is the color.
It is somewhat generic.
Or in the city.
And he didn't see his face. And even in the Boyer case, which I think is our case is even weaker, actually, a better case.
Really?
Yes, because in Boyer, the detective, I think his name was Clemens, said that he saw his facial hair. He had facial hair.
He sees him for a few seconds on a fire escape, I thought, in Boyer.
But he saw in this case, Detective Vanacor, and nowhere in the description, the radio description of testimony, did he say he described the seller's face, whether there was hair or not. I mean, really, if you're going to depart from the notice requirement, it's got to be a really tight exception. And in Wharton and Rodriguez, the two factual situations, it's the nature of the prior relationship, a brother identifying a sister, face-to-face, up-close encounter, that could not be mistaken. There's zero risk. And then the Court should adhere to that. I'm not saying a ghost can never make a confirmatory ID, but it would be the rare case.
Okay, counsel,
Thank you, Ron.
thanks. You'll have your rebuttal. Counsel.
Good afternoon, Your Honors. May it please the Court. Brian Poyot on behalf of the people.
Counsel, go ahead.
Does Boyer control this?
Your Honor, I don't believe that Boyer is in any way analogous to this case. As the Court has realized in Boyer, the police officers were not on the scene as part of a planned buy-and-bust procedure to locate and identify suspects as they were here. Rather, they were responding to a 911 call. They get to the scene and they're trying to figure out what's going on in these rapidly unfolding events. They see defendant.
Mr. Kaplan's point, if I understand it, is that 71030 is definite. It doesn't provide any exceptions. You have to give notice. And then a couple of exceptions have popped up where, obviously, if it's a spousal assault or something, or a brother, sister, you know, where there's just no doubt, we've made this exception. He wants a zero tolerance. And what's wrong with notice? I don't understand why a 71030 notice would have listed both of these officers. They would have made the argument, you know, that they want to wade. The judge would have listened to you, or, you know, the people argue one side or the other, and he said, no, you don't get a wade. But to stop a trial in the middle because somebody didn't tell them that this officer was coming, and then we accommodate the fact that the people did not do a 71030 on this, and we have a Wharton hearing. It's wholly unnecessary and didn't have to be done, or if it was going to be done, as the statute provides, would have been done speedily, early, as pre-trial pursuant to the statute.
Your Honor, if your question is why 71030 notice wasn't given, I don't think it is required.
No, I'm saying why don't you do it? And I understand you're going to say it's not required, and we just keep frittering away. I don't know if this how this. We don't know if police lie. There's rumors on occasion that they will strain the truth, or they will absolutely not tell the truth. And if we're going to say, well, you know, the police officer said I had a clear view, absolutely the defendant, no question about it, then why have a 71030 at all? And it just seems to me you're better off doing the 71030, having the hearing promptly, and then going to trial.
Your Honor, I can tell you that our policy is to give 71030 notice, which is why we gave it as to the primary undercover. It appears from the record that this was just an oversight as to the second officer. But what I can say is that as soon as it came to light, the Court, as you said, stopped, had a Wharton hearing, and at that Wharton hearing, I think.
So you're saying it's not a policy to not give the notice if you don't think it's strictly required. It just didn't happen here because of an oversight.
Your Honor, yes, I'm saying that the policy of our specific office, the Manhattan DA's office, is to give.
Now, if it's an oversight, don't you have 15 days? Or you're precluded?
50 days to give notice, Your Honor?
You're precluded. If it says, in the absence of service of a notice upon defendant as prescribed in this section, no evidence of any kind specified subdivision 1 may be received against him.
That's correct, Your Honor, but as we recognize, there's no requirement for notice if the notice is confirmatory. Our policy is.
I know you're not missing my point. It just seems to me that statute says what it says, and as Mr. Kaplan is saying, we've done a couple things. We've said, you know, obviously, but it's just a waste of time. I'm not even sure you shouldn't give it then, but if it's a waste of time, and even in the cases we've had, we're arguing about whether or not there should have been a waive. That is a decision by the judge when all the cards are on the table. When you say these are our witnesses, and the defense can argue, you know, against them, rather than being, you know, come out later on in the trial. So.
I apologize if I'm not addressing your question. I am trying to, Your Honor. If you're asking why we didn't give 71030 notice, I'm afraid to respond again that we weren't required to. But I do know the statute says we're required to give notice, but I would direct you to Boyer, where this Court said that under these circumstances, where an identification is confirmatory, the Court said.
But wait a second. But under Boyer, the initial viewing is what's most important. You're saying this case has no relationship to Boyer?
I am, Your Honor, as I was making my point earlier.
What case does it have a relationship to?
I think this case is Wharton, as stressed in Wharton.
It's Wharton if you never heard of Boyer.
I don't believe so, Your Honor.
Boyer didn't change the whole equation in these kind of identifications.
I don't think so, Your Honor. And I believe my adversary, as he said, Boyer, he even believes Boyer didn't change it. Boyer just maybe put a gloss on it.
Boyer is a much narrower view of this whole area and emphasizes the initial viewing and the quality of that initial viewing. Anyone reading it would recognize that. I think you recognize that.
I do recognize.
The initial viewing is very important, how far it was. You know, there is a relationship to Boyer. You may want to say it's in between, but Boyer sets the stage for our present law on these kind of confirmatory situations.
Your Honor, I do recognize that Boyer stresses the quality of the viewing, and I think the only relation to Boyer that we have here is the distance. It's not face-to-face. That's the only way in which this case is similar to Boyer.
But that's the most important thing of Boyer. It's the quality of the initial viewing.
Yes, Your Honor, but I don't think that distance alone is what leads to quality of viewing. Here we have an undercover, as I said, who's on the scene to identify him. He may have been across the street, but this is a one-lane street. We're talking about one-lane street.
But I get it all. I get it. I understand your arguments. But as just Pacquette mentioned before, it's a rare thing that we do it without notice. It really has to be a total no-brainer that it's just confirmatory in order to not have to follow what's the normal procedure that's there for a reason. Because sometimes there's too much suggestiveness, and that's what this is all about.
Your Honor, I would argue that this case was a no-brainer, much like Wharton. And to also clarify my point, I believe we cited in our brief several cases from the different appellate divisions that have said that ghosts can make confirmatory IDs. I think that's the real question here. Is Wharton going to be constrained only to the face-to-face purchasing officer?
Notice. I absolutely agree with you. I think if there had been a 7-10-30 notice there, and Vaneker's name was on it, and you had an argument before the judge, he or she may very well have said, this is confirmatory, that's it. And then you go to trial.
Your Honor, if I may quote Boyer for 1 second.
Sure.
Not relating to the quality of viewing, but just quoting Boyer. We have recognized, however, two instances when, as a matter of law, the identification at issue could not be the product of undue suggestiveness. Under such circumstances, the defendant is not entitled to a Wade hearing, and thus the people are not obligated to provide notice pursuant to CPL 7-10-30. That is saying that if we believe it's confirmatory, if an identification is confirmatory, then the notice requirement doesn't apply.
Which leaves to you, as opposed to the judge, the right to determine when 7-10-30s are going to be given and when and if the ID is confirmatory. And I don't think you would want that responsibility. And since the law says give them notice and then you go into the judge and say, Judge, it's confirmatory, we're done, let's go pick. It's over, as opposed to what happened here where in the middle of the trial you've got to have a Wharton hearing.
I don't believe, sir. I don't believe it leaves us the burden, the responsibility, burden, or I believe what it leaves us is the risk. And I think that that's one reason that this thing is not going to be overused.
The part you didn't cite is what Judge Case said in the beginning. She said the people ask us to extend the confirmatory identification exception derived in Wharton to a situation where a police officer's initial encounter with a suspect and subsequent identification of that suspect are temporarily related such that the two might be considered part of a single police procedure. To do so, however, we would run afoul of 7-10-30. Moreover, such an exception would eliminate the protections offered by a Wade hearing, even when the initial police viewing, albeit part of a single police procedure, was fleeting, unreliable, and susceptible to misidentification.
Would you like to talk about harmless error for a while?
Your Honor, may I answer your question first?
No, you can skip me. Go ahead.
That wasn't a question.
Your Honor, I would argue that this is not a situation, as outlined in brief, that was fleeting, unreliable, and susceptible of misidentification. As I stated, I think this is Wharton. I think the factors stressed in Wharton were, quote, that the identification was not of a kind ordinarily burdened by forbidden suggestiveness, and as Wharton stated, that is because it's a trained undercover narcotics officer at a time and place sufficiently connected and contemporaneous to the arrest as to constitute the ordinary and proper completion. I do understand that Boyer stresses the quality of viewing, but I do not think that this is Boyer.
A good idea to go to harmless error.
Thank you, Your Honor. I do believe if there's any error in the Court's ruling here, it was harmless. As the Court has realized, we also have identification, both confirmatory and in court, from the face-to-face officer, which even my adversary indicates is the sort of gold standard confirmatory.
Is the mark bills
the defendant
real key area?
I don't know if it's the key. I do think it certainly adds to the weight of the evidence. The defendant was found with the exact same $20 in pre-recorded buy money on his person that was used by the undercover.
Can I just clarify, are they marked bills, as the Chief Judge said, or is it just the denomination matches?
They were pre-recorded. I believe the serial numbers were recorded, Your Honor.
Okay. So it is the same money that transacted.
Absolutely, Your Honor.
Okay.
And while the defendant did provide some explanation, as defense counsel suggested, I don't think the explanation made much sense. He says that in the interim he had time to go to the diner and get change. And in court he was also adamant that he received 29 singles in change, whereas here we're talking about a 10, a 5, and 5 ones. We also do have the consciousness of guilt evidence. He's running away. And the police officers collectively, I would point out, never lost sight of the defendant. Vanacore did see him start running, and he ran in response to another officer.
Okay, counsel.
Thank you, Your Honor.
Thanks. Counsel, rebuttal?
Thank you, Your Honor. Judge Pacquette, I was going to read Judge Kaye's quote. You beat me to the punch. There's no exception for because the officer is a veteran or that the initial viewing and the subsequent transaction are temporarily related. I mean, if the detective is in a fog, it doesn't matter. It's all as.
What about let's go to the harmless. What about the marked bills and all?
He did have pre-recorded buy money on him, Your Honor. That is not a good fact for the defense. He did give an explanation in the case Fernandez Rodriguez that the prosecutor cited that this was doom, the kiss of doom. My client gave an explanation of why he had the money. He said he bought, but I do want to focus the Court's attention on the second prong, because even if the evidence, if this Court were to find that the evidence is overwhelming, under the second prong, if it infected the verdict to a considerable degree, and I want to argue, and it's in footnote 3 of my reply, that it's a constitutional error. The 71030 statute facilitates and is designed to enact protections, due process protections.
Do you think it's so important that piece, the second identification?
The second identification, I think, bolstered the purchasing officer.
And even despite the other evidence, that's the
yes, I don't think the jury. I really don't think the jury would have found him guilty. That's why the people put him on.
Are you arguing for a per se reversible rule?
No, I'm not. I'm saying in this case, because the purchasing officer's testimony, the remaining testimony, is weak, and there's an explanation for the pre-recorded buy money. And Van Oker was such an excellent witness, and that his testimony affected the verdict. Thank you, Your Honor.
Okay. Thank you both. Appreciate it.